Recourse.com. I received a question, and rather than just talk about the question or get too much into client confidences, which I wouldn't do, I'm going to turn this into a generic, but useful. What would go on with our process? Like if you called, if you found Upside Down Real Estate on the net, you clicked on the advertising link, how would we start? Well, I could just answer questions, but before I do, I have to establish a baseline. So for me, if you're still current, if you're not current, sometimes we have to do other things. If you're in foreclosure, we would start with a different set of calls. But I'm sorry, I should have removed my phone from the room. So the first question I have is I want to examine your original loans. I want to know if they were purchase money loans or if they were the equivalent of purchase money loans under California law. And so I wrote this down. So the first thing I'm going to do is a recourse, non-recourse analysis. So we're going to do that on your first loan or your second loan. Today we'll just examine one loan. If you have two loans, be very careful of doing a short sale. You do not want to be in a sold out junior situation. Definitely talk to a lawyer. I already have videos on it, but you don't want the first to foreclose on you if your second is a recourse loan. So that's like the baseline statement for anyone with two loans for me is I always want to know if that second loan is a recourse loan or non-recourse loan because it changes the way you should do things. But today we're going to examine one loan. And so my first question is, at the time you purchased the property, how many loans did you take out? And for this scenario, the answer would be one. And I'd say, do you know what you paid for the property? Do you know how much of a loan you took out? So we're trying to establish, let's say you bought a $1.2 million property and you had $1 million loan, just for round numbers. Now, my next question for you is, did you ever refi? And sometimes it's so long ago, people don't know or they forgot. So I do try, we can do all the analysis, but I do tell people before we get far down a road of foreclosure, we would definitely want to see if you can locate those original loans. We can get them from the banks, but you always want to examine your documents, but we're not doing that today. But now let's say that they took out $1 million, they paid it down to 900. At some point they did a refinance to get a lower rate. Like I got a lower rate, and I imagine a little bit of my loan, because that's the way lenders do things. Like I didn't really get a cash out, but to get a lower rate and those guys let to get paid, they sometimes increase your balance a little bit. So we're going to track that down. For round numbers again, let's say you paid it down to 900, you did a refi, and now it's back at $1 million, or it was back at $1 million. It gets more complicated after that, because when you're paying, it should go to your principal, but we're not going to worry about that. We're going to just say you have a $900,000 purchase money protection under California law and $100,000, which could be non-purchase money, which might be recourse. One loan, hybrid. So part purchase money, part recourse. So now I'm going to, with you, establish a baseline. And in my scenario, most likely the baseline would be that if the bank foreclosed, because that's the worst thing that could happen, the lender doesn't agree, or you choose to not, you want the time, or you don't want to expose your assets, you don't want to plead a hardship. The bank, we work together to try to get the bank to agree to do a deed in lieu or short payoff or short sale without you having to show your hardship or your financials. And for some reason they rejected it. Now, I wouldn't expect, if you start early, to them reject all your options. But if you maybe contacted a lawyer late, so your baseline is what happens if the bank forecloses. Now, I would tell you that because of the way California laws are set up, when the bank forecloses, it's 7 CCP 580D, and there's like 720. There's a few laws. It doesn't matter. We don't want to get that technical. When the bank forecloses, the bank loses its right to collect the deficiency from you. And alert people will then ask me, because I might have said when the bank forecloses in a non-judicial manner, the bank loses its rights to go after you for the deficiency. And we're going to analyze this from deficiency, taxes, and credit standpoint. And then you might say, well, what if the bank forecloses judicially? And I'll say, back in the last round, out of talking to close probably to 1,000 people on the phone, over, if not more, I mean, because I had hundreds of clients. We did 200 short sales. We did a large amount of walkaways. We did short payoffs. We did deed in lieus, 4 loan mods. The banks were taking so long. I was like, I don't want it. This is no way to make money. I mean, literally, I think I talked to 1,000 people on the phone easy over those 5, 6 years, 7 years. And I would say they both became clients, 2 people where the banks were trying to foreclose in a judicial manner. One of them I remember well, and the bank actually said, well, we had a problem with title. We just have to work this out. And we found a way to work it out. And the other bank was just not intelligent. And I looked up the law and I was like, because the rule is you could go into court and you could say, look, if they're choosing they have the way the law is set up in California, if they do a judicial foreclosure, they can really, really, really screw up and lose the right to come after you for the property. And then you got to keep the property and they couldn't get a judgment against you in certain circumstances. So let's just say that bank backed away really fast after my client said, I don't want to spend money trying to sue them or defend this. So we called them up and I talked to their legal department and they were gone. And, instantly when they realized how badly they screwed up in California. I was surprised their litigators didn't tell them that. So really, they cannot go after you because of the security first rule in California because there's punishment. It's not automatic, but there's punishment. So they're almost always going to come after you for a non-judicial foreclosure. So that is your baseline. There is no, it's very unlikely, unless there is fraud after a foreclosure, that they're going to be able to come after you for the deficiency. So your next question should be taxes. What about taxes? Will I owe the IRS? And that is a more complicated matter, but I would say in the circumstances I've investigated, because of the circulars and I have some of it on my website. I would think that most of the time you could feel comfortable that you will, when the bank sends the 1099-C for income, under most circumstances, you don't have to worry about cancellation of debt income, but you might worry about capital gains. And then the final part of this analysis, well, the fourth part is time. The third part of this analysis is credit. Now, typically, taking a foreclosure is going to be, everyone's going to advise you that your credit would take a bigger hit than just about any of the loan workouts. Now, I can tell you that in the past, the California foreclosure timeline was far shorter than it is now. And sometimes we had the anomaly that short sales took so long to negotiate, and foreclosures, once the bank started to close, if the banks were aggressive, they might get it done in like less than 130 days, let's put it that way. And the amount of credit reports that came in and the foreclosure, and it had something to do with maybe where they were ahead of time or how strong, or sometimes people were taking foreclosures and their credit wasn't getting as damaged as the people who spent a long time doing short sales. And we heard of those occasional people that took foreclosures and were able to get loans in a lot less than 7 years. I would say there's 2 things to worry about there. One, those people were overall an anomaly. Most people are going to be shut out of getting a mortgage at a good rate for 5 to 7 years, just after talking to clients, talking to people, and reading. And secondly, I'm not so sure in California that credit won't be hammered, because there will be now many more months of being late. Because in addition to the California foreclosure timeline, there's now 4 more months of a federal cooling off period. And on top of that, we can have leverage to stop the foreclosure for another 45 to 90 days, just with things that I can do as an attorney broker. And that would be just putting a property on the MLS and notifying the proper parties to delay the foreclosure, and then make sure they're not being dual tracked under California law. So you can buy 45. If you have a legitimate offer, you can buy 90 more days. And they normally take a long time to review foreclosures. So the foreclosure timeline now is 4 months longer for sure. And it could be 6 months longer. And these are the minimums. So really you could be looking at a year. So while it will hurt I'm sorry, I should have shaved better. While this foreclosure timeline might hurt your credit, and it's actually leverage. This, because a bank's going to have to wait so long to recover the money let's say it's an investor who owns this pool of loans, and we would be talking to the loss mitigation department, because I don't like, I'm definitely going to ask if I've got a client offering a deed in lieu, and my client's still current on their loans. They're not taking hits, late hits yet, and we're trying to work this out. And I explain to that lender that it's going to be a year before you get the property back, and I'm going to advise my seller on those last few months of the loan that they don't want the property to go to waste. They should move out. But we could put renters in there at below market rates. We could be explaining to the investor, and then if they're not listening, I mean, to the loss mitigation department. And if that first person we talk to, because these people are probably in other states and don't know California law, and they think, oh, everyone hates a foreclosure, everyone hates the taxes that we're going to send to them, so they'll work this out with us. And we have to explain why California law is, when it's true, my client's not worried about a foreclosure. My client's not worried about owing the bank money, owing taxes. So really, the only thing you have over my client is we need to negotiate credit. My client doesn't want a credit ding. In exchange, he'll give you the property now, and we'll get you clear title. I'm an attorney. I can make sure we work with, like, a lot of people in other states want to do foreclosures because they don't understand title in California, and they want clear title. And they're like, I've had them tell me this. The reason why we won't do this deed in lieu is because we want clear title. And I'm like, I can get you clear title. We can work this out. Foreclosure title, if you get clear title, it doesn't matter where it came from, a foreclosure or not. I'm a lawyer. We can accomplish this. We can work with escrow to protect you. Let's work on this. So I can tell them, look, you can do this deed in lieu with my client now. And why my client's doing this is because while they're not really very upside down on your property, by the time they pay realtor commissions and we pay a buyer and we pay escrow and closing costs, they're going to be negative with you. And we're trying to avoid that. So we're going to get you this property now. It's back at almost full value. And if you don't hurt my client's credit, you can have it now. If you're not going to work with my client, then, we go through all the reasons why a client who's represented by a lawyer is, their investor's going to lose 10% of the value of their investment. Maybe, that might be a long shot, but 15% is realistic. And if you're looking at present value and time value of money, seriously, we have a lot of leverage. All we're asking for is, because we're working with you, you don't harm the credit and you get this asset back. So for many people who, you could try to do this yourselves, I would think you'd want a lawyer to have credibility. We would explain the laws, we'd leverage it. We'd find, if the loss mitigation department, I'd try to escalate. If they're no good, we're going to use different laws and RESPA requests to find out who the investor is. And we're going to put a package in front of them and try to help you. If it doesn't work and you're going to do a short sale, like the money and time we spent there will eventually be ready for the short sale. But I'm going to talk to you then about, well, do you really want to do this short sale right now? The bank's not willing to work with you. They're going to make you go late. It seems like they're going to harm your credit. Why don't we wait 6 to 9 months before we do the short sale? And then you get to live in the property for free. And there's reasons why you wouldn't, and we'll discuss them. But my point is that in this market at this time, for most people, I don't think the short sale is the right way to work things out. And the other warning I have, and I should have said this early in the beginning, is that if you're close to being whole, and it's really only the expenses that you have a problem with. So in other words, the 5 or 6% most realtors charge, the 1 to 2% in closing costs, like escrow fees and maybe paying off property taxes or HOAs. So we'll call it 8%. If the reason why you're going below zero, you're going negative with the bank, is because of all those fees, find ways, negotiate with escrow, make your realtors agree to peel down their commissions. There's ways to not even have to go zero. Work, in our office, I just went full throttle with Phil, who works with me. I was like, let's just establish a flat fee situation with our clients. We can say, look, we'll peel down regular commissions down to like a $5,000 level before my client has to go short. And even then, I'll find a way to still help you or advise you. So just don't necessarily go short because of your realtor fees. So I think I walked you through the process. If you'd like to know more about the laws that we're leveraging in California, I can tell you there's 580B, there's 580D. Those are CCP 580B, CCP 580D. 580B is purchase money loans. We sort of discussed that. 580D is the actions after a foreclosure. There's the one action rule, security first rule, all available at upsidedownrealestate.com to research. There is 580E, which is the California short sale rule. And if you're going to do a short sale, I'm going to talk to you about whether your realtor is going to tell you need a hardship. Your realtor is going to tell you should disclose all your assets. Some realtors told their clients to fudge. I don't like any of those. In the right circumstances, we might show a hardship if you really have one. You might show your assets, but make sure there's a few things you want to make sure. You don't want your workout package to be a lot different than your loan package unless your circumstances really have changed. Because some banks, during the last foreclosure and short sale scenario, they were doing a quality check. After they did the short sale, they would then look at the loan approval and they look at the short sale approval and see if there was incongruity. Incongruous? Yeah. So anyway, they were seeing if there was lies. And then they would look for fraud. And if they found fraud, well, then you wouldn't have the protections of the anti-deficiency and the taxes. 580E might not apply. It says it on its face. It doesn't apply. The bank can go after damages if there's fraud. With respect to taxes, I don't know how the IRS would handle that. So at this stage, after we go back and forth and I explain those things to clients, I'm going to talk to them about their goals. Do they have time frames they're concerned? Do they prefer some options like do they have a chance if they have two loans? Are they looking for a short pay, especially in a zombie loan? But we're going to go over all their options. I can say that if you're doing a loan mod, I coached clients during loan mods. You could call up, but I'm not going to do the loan mods. The banks used to lose them and drive people nuts. So I would stay in touch. I might help you gain leverage, but I would not be your point person on the loan mods. Although if you're interested, I would say just don't let them foreclose on you or even start the process while you're in the loan mod. But otherwise, short payoff, we definitely look at deed in lieu. We look at short pays for if you have two loans. Like if you have two loans, a short payoff can be an awesome deal, because if you get all the second to go away, you might still have equity on the first. You might not even need to move, but if you did, you might get money. So short payoffs are good. Deed in lieu's, walk away plans for some of you are just like, I don't want to show my assets to the bank. I don't have a hardship. I don't want to stay in this house anymore for whatever reasons. And what are my options with respect to a foreclosure? And that would be a walkaway plan. And we'll tell you your options. We'll tell you how to monitor it when you should begin thinking about moving, how you can delay it and stay in the house much longer. How you can, you're going to get harassed by creditors. If you're working with a lawyer, we'll have cease and desist letters, and you can tell them to, I'll have a number to send to. You can send people who harass you to. We'll go over your tax liability. We'll give you some ideas of how to fight your credit or mitigate damage. I'll give you letters that we'll draft. I remember doing that for people last time. Sometimes they work well. So we have a host of programs, and we will ask you to, well, for now, while you're seeing this, we'll do our recourse, non-recourse analysis and give you your options for no charge. But it will require, so we're both having useful conversations, it will require you to fill out, and I know some people don't want to fill out the form on the page. They're worried about security. So you call us, and then we'll email it to you, and we'll work out a way that you get us that information. But for instance, in the forms below, we're going to want to know what your property's worth approximately. I mean, yeah, I'm an attorney and broker. I can look it up, but I want to know what you're thinking. I want to know what you took when you took out the loan, how much it was. Did you ever refi? What you owe now on the loan? And these can be rough values. I don't need actual payoffs, but I want to get an idea of whether you have a purchase money or a hybrid. I want to know how many loans there are. And in the form might ask you, what are you interested in? Some people are only interested in a short sale. Some people are only interested in a deed and lieu. Some people are only interested in walkaway plans. So, when I'm reviewing your loans, before we have a conversation and I'm thinking about the things that I need to ask you, I want to know what to focus on. I mean, I'll talk to you about everything, but I want to know, like, if you say 2 loans, but you want to do a walkaway plan, we're going to spend a bit of time discussing before we actually go over your options, because I'll need to nail things down. So my name is John McConnon. I'm a broker and attorney in California. With respect to short sales, my office, we've done close to 200. I have been asked by the California Association of Realtors to train home sellers on their options. And I would say this. Let's see if I can pull that up right now. Yes, and I'll go here. I want to say, before you talk to a real estate agent, make sure that you have, and if you want, I'll send you a copy of this. You want to, where did it go? Oh, there it is. Good. That's what I wanted it to do. The reason why I find this so valuable is because California Association of Realtors, their lawyers were good on this. They talk about, there's a few changes I would do. I wouldn't agree to make it easy for there's something in one of the, so let me just start off. Credit, legal, and tax advice. Sellers advised to seek advice from a qualified California real estate and tax attorney. It sounded like I was like, oh, that's me. Yeah, well, I am. They had me train realtors on short sales, and I've been doing this for a year. My site, upsidedownrealestate.com, I got the URL in 2007. You can see it in 2007 or 8 on Wayback Machine. You can see all this information, all of it. Well, some of the recourse, some of the loan, 580E was not there in the beginning, but it was there on the website. Like if you go on the Wayback Machine, 2012, 2013, but you'll see, I was talking about taxes, loan mods, short sales, the whole thing. So, they're saying you need that information, but here, this is short sale addendum. Oh, I wanted, sorry, the short sale. This is what you will have buyers sign. And the important thing here is that you want to make sure that with respect to short sale approvals, nobody gives the buyer the terms, the approval letter, before you've had the letter approved by an attorney. And they say that again here too, right? I mean, seller is informed that a short sale may have legal or have credit or legal consequences and may result in taxable income to the seller. Seller is advised to seek advice from a qualified California real estate and tax attorney. They're not kidding. They say that in other places. In the short sale listing addendum, they say it in multiple places, but I wasn't expecting this one. The seller's term sheet, this is it. Buyer nor seller shall be obligated to continue negotiations to satisfy any of the requirements of the term sheet. So what they're saying is that when you get the lender approval letter, the buyer can review it and the seller can review it, and no one's obligated to close. Either party may cancel the agreement in writing. Seller is advised to seek legal, because this is really important, those terms, tax advice before agreeing to such changes. The parties must agree in writing to the changes to the written consent or term sheets before continuing under the terms of the agreement. If the agreement is canceled, buyer shall cancel. So both parties must agree in writing to the changes in the written consent or term sheet. So I would say the practice among realtors has been to take the approval letter, say we got it, and send it over to the buyer, and they just start closing. And I'm saying the proper way to do this is to have an attorney review it before you let anyone give the buyer consent to go ahead and start the closing process, because they're going to start spending money on inspections. and maybe canceling out of other offers. So, and then that gets you in hot water. So make sure your realtor is on board, or you can work with us. I mean, as I said, we sold 200 homes all over the state. And even if we're not in your area, I can refer it out to a realtor in your area, and I can oversee the file. So for more information, just fill out the form or give us a call. You'll see the number. Thank you. My name is John McCullough.